that, you know, kind of unlike the Fourth Amendment, when we're talking about Fifth Amendment issues, we're talking about two general issues, right? Voluntariness and Miranda, okay? Those are the two broad issues that are addressed in Fifth Amendment cases. And so we start out right here, we talk about the standard for consent, dealing with both the Fourth and Fifth Amendment, on page 6 of these handouts. For the Fifth Amendment, a confession must be voluntary in order to be admissible for any purpose. You're going to see a question or two about that. You're going to see a question or two about when can you use an involuntary statement, and what's the answer? You can't. You can't. Involuntary statements, if they're deemed to be involuntary, you can't use them in court in your direct evidence. You can't use it to impeach the defendant if he testifies. You can't use it to rebut the defendant if he testifies. Okay? It's a pretty simple principle. And that's a major difference between when a court addresses voluntariness versus Miranda, right? Because is the same true of Miranda violation? No, it's not. Okay? If there's a Miranda violation, the courts have ruled that when they invented that Miranda rule, which they have subsequently held to be constitutional in nature, it was never intended to allow a defendant to commit perjury. So if he gives a statement, and later it's found that the police violated his Miranda rights, and that can happen in a number of ways, right? First of all, you have to know when to provide Miranda rights to an accused, correct? That's the first thing, and that's simple. We're going to get that in a second. The second is, if he invokes one of these rights, and the police continue to question, other than the one time we'll talk about when that can happen, that's a violation, right? If he asks for an attorney, you continue to question, can't use it, right? Can't use it in your case in chief. If he gets on the stand and says something different from what he said to the police, and there was a Miranda violation found, we can use that statement to rebut his testimony. Okay? So that's a major difference in these two broad issues that you need to understand when you take a look at some of the questions you're going to be asked. Okay? Look at the Fifth Amendment. No person shall be compelled in any criminal case to be a witness against himself. Okay? Testimonial evidence we're talking about. And what I did was I read from the slide at the bottom of page 6, the words that are in bold, the ones we're concerned about with the Fifth Amendment. No person shall be compelled in any criminal case to be a witness against himself, or witness. It doesn't say that you can't compel the defendant to provide evidence, does it? It's to be a witness against himself, which means testimonial in nature. Can you force the witness to provide hair samples, blood samples, handwriting samples, fingerprint samples? Sure you can. Those are all physical evidence. You can be compelled to be a witness, testimonial, words he speaks. Know what the standard for voluntariness is, and it's pretty simple. You know, the standard for voluntary, it's voluntary if you had a choice. If all the circumstances, you look at all the circumstances, and a reasonable person would believe they had a choice to answer the questions or not answer the questions, right? It's involuntary if the maker's will has been overborne by the police, okay? Now look, I want you to consider this as a two-step process. The first step is, was there police coercion? There's going to be one or two questions on this final exam that test your knowledge of this. If there's no police coercion, is the statement that that person gives going to ever be held involuntary? The answer is no. Now we're going to look at factors, and some of these same factors that are considered in determining voluntariness are likewise considered in the question of whether or not the police use coercive tactics. Remember, I told you about a very long interrogation that our police conducted not too long ago, where they yelled at the person, they used deception, they lied to the person, called their names. Those are coercive tactics. The question is, was the defendant's will overborne by police coercion? Okay, so you must have some police coercion. And that comes into play, folks, especially when we talk about mental or emotional disorders, right? If a person comes into the interrogation room with some personality disorder or some mental disorder, and the police don't try to exploit that, and there's no police coercion, then that's not going to be held to be involuntary. Talked about several cases that dealt with that. You remember the detective sergeant who had the fellow who was alleged he had done some improper touching on a relative, plot and killed, wasn't it? And what the police officer, first thing the police officer recognized when he came in, I recognized that he was slow. Remember that case? But did he take advantage of that? No. Short, simple sentences. He used some of the same phrases that the defendant used. That's a good case that illustrates this concept. One of the cases cited in that case is Colorado versus Conley. I think I mentioned to you, that's a case where a criminal came to the police and said that he heard voices commanding him to tell the police where he hid the body of someone that he killed, right? And this Colorado Supreme Court said that that made his statement involuntary because he was hearing these voices commanding him. And what did the U.S. Supreme Court say? You got it wrong, Colorado Supreme Court. It's police coercion that must overbear his will, not something else. Okay, keep that in mind. And these factors determine voluntariness. Remember, these are all factors. Now, we did talk about how some are more important than others. For instance, deprivations of physical comforts is a factor concerning the conditions of the suspect. We know that that can be more problematic than the use of trickery and deceit by the police, right? But all these are factors that the court is to consider. The factors concerning the suspect, its intelligence, education, prior experience with the police, use of drugs or alcohol, emotional or mental disability, deprivations of physical comforts. Those are factors to be considered. It's still a totality of the circumstances approach. And then the factors related to police tactics. And which of those did we see are more problematic? What's the most problematic of those four police tactics listed in the side at the bottom of page 7? Threats of promises, leniency. That is a factor that weighs heavily in determining voluntariness. And then review these Miranda slides, okay? And remember, it's very simple. What we talk about is how can a person's Miranda, what are the person's Miranda rights, first of all, and how can they be violated? Well, the Supreme Court has said his rights, a person's Miranda rights means that when a person is subjected to custodial interrogation, that person must first be advised that he has the right to an assignment, that he has the right to have an attorney during questioning. That's the way I want you to remember this Fifth Amendment right to counsel. Because we know now that we also have a Sixth Amendment right to counsel, right? The right to have a counsel for your defense. The Fifth Amendment right to counsel is to have counsel present during questioning. He must be made aware of those. We don't deal too much with the one that says if you can't afford one, one will be appointed by the court. But we know that is one of his rights. The two that we're concerned about is what takes place during an interrogation, if one takes place. So, was there custody? If so, was there interrogation? We got to know what those are, right? Custody is not defined by not being free to leave. Remember, that may be a detention, but that does not mean it's a custodial situation. It's a formal arrest, right? Formal arrest. An interrogation means what? Anything the police do or say designed to elicit a confession. That's pretty much the best definition you can go by. What does that exclude? Well, it excludes what we call booking questions, right? It excludes questions about what's your date of birth, what's your social security number, where do you live, how tall are you, what do you weigh, things like that. They're not designed to elicit confession. They're not interrogation. So even if he's in custody, booking questions do not trigger Miranda. What does trigger Miranda when a person's in custody? Interrogation. Interrogation. So we have to know what's custody and what's interrogation. Am I doing something? Am I saying something? Am I asking something that's designed to elicit a confession? That a reasonable police officer would know is designed to elicit incriminating statements. So once we know what custody and interrogation is, then the slides start talking about those individual rights. Oh, by the way, what else is excluded from the definition of interrogation? Yeah. Public safety questions are an exception. They may be designed, they may actually elicit incriminating statements, but because they are designed to protect the public safety, that becomes an exception to the interrogation requirement of the Miranda rule. But I want you to think about something else that's excluded.
Spontaneous statements?
Excuse me?
Spontaneous statements?
Spontaneous statements, right. It's not an exception, is it? It's not an exception like public safety questions are an exception. It's just that spontaneous and statements by a defendant is not in response to questioning, right? If it's not in response to anything the police do, then it's spontaneous, if there's no interrogation. Keep those principles in mind when you read some of the fact situations, and you'll understand the correct answers. So then the slides start talking about if someone says, now also what you need to know, of course, is that to invoke his right to remain silent or his right to an attorney during questioning, a person must do what? Invoke them how? What's the court say? Excuse me? Unambiguous. Unequivocally. It must be a clear invocation. Okay? Maybes don't cut it. So, first of all, how does someone invoke? They invoke merely by saying, I don't want to talk. So merely by saying, I want a lawyer. Those are unequivocal, those are unambiguous. Unlike, remember the Boulding case? Didn't you say I could have a lawyer? Sure did. Well, can I have one right now? Sure, if you can get him here. Has he said I want a lawyer? No, he's not done so unequivocally or unambiguously. So there's no indication at all. Okay. But once he does do that, once he says, I don't want to talk during custodial interrogation, once he says, I want a lawyer during custodial interrogation, must the police stop questioning? What about if he says, I want a lawyer? Do the police have to stop questioning right then? It should be easy for you. Yes. What if he says, I don't want to talk to you? During custodial interrogation, do the police still have to stop asking questions? Yes. Okay, good. Yes. When he invokes either right, unequivocally, during custodial interrogation, the police must stop asking questions. Now, the next step is, can they try again? How about if he says, I want a lawyer? Can he try again? Tell me. No, no. How about if he says, I don't want to talk? May the police try again? Yes, okay. And these factors, these next factors that are in these slides talk about what the court's gonna look at. Because you can't just keep asking me questions. What's the word that I used? Quoting the Supreme Court about what the Supreme Court goes the furthest distance to keep from happening. What do they call it? If a person says, I don't wanna talk. Oh, come on, why not? You must be guilty. Yes, what?
Badgering?
Badgering. The Supreme Court has said that the police cannot badger a suspect into changing his mind once he says he wants a lawyer or he doesn't want to talk. In both of those circumstances, the police must end the interrogation. If he said, I don't want to talk, the police can try again a little later, right? At least a couple hours later, what's the court gonna look at? Did you first advise him of his rights? Of course, that's the first thing they're gonna look at. When he was subjected to custodial interrogation, did you give him his rights? Yes. Did you stop asking him questions when he said, I don't want to talk? Better have. Whether you waited a significant period of time, okay? And we've all talked about, we're talking about hours, not days or weeks or months. Next, whether you gave him his Miranda rights again, whether you made sure he understood his Miranda rights again. Why? Because he invoked one, right? If he doesn't invoke one of these rights, a voluntary waiver is presumed to continue. But if he invokes one, you gotta start from scratch, right? Okay, you remember I told you, you have the right to remain silent. You still have that right. The right to an attorney to be here while we're asking you questions. You still have that right. But you indicated you're willing to talk to us. And then whether you don't come back with the same questions right away. The way the court put it was whether the second interrogation was limited to a crime that had not been the subject of the interrogation. Since that language came out, we've seen in the Weeks case and in others where the court indicates that just because you got back to the same topic doesn't mean that it was an invalid constitutional under Miranda. But those are the 5 factors that the court's going to look at. And you recall the Weeks case where the court looked at all those factors and said, his post-invocation statements were admissible. When he finally admitted, when Weeks admitted, he shot Trooper Tomasos. Now, what about when he says, I want a lawyer? You gotta know what the rules are there. He says, I want a lawyer. Police can't talk to him again until one of 2 things is happened. What's that? Huh? He has a lawyer, or what? He initiates about the offense. He initiates conversation about the offense. Otherwise, if that doesn't happen, if he stays in continuous custody, it not only applies to the offense those officers were asking him about, but once he says, I want a lawyer during custodial interrogation, it applies to any offenses and all police officers so long as he's held in continuous custody. Okay, we understand that? Now, once he's released from custody, all bets are off with respect to other crimes. And in fact, if he's not in custody, he doesn't have a right to have an attorney with him. Any questions about any of those Fifth Amendment issues? Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. When does that attach? At formal adversarial proceedings. Understand this, what's the main difference between the Sixth Amendment right to counsel and the Fifth Amendment right to counsel? Can both of those rights be waived by the defendant? Yes or no? Absolutely. I cannot think of a right that the defendant has that he can't waive. Can you? Of course not. They're his rights. If he wants to waive them, he can do so. Once a person has counsel, once his Sixth Amendment right to counsel has attached by adversarial proceedings, and he's indicated that he wants to exercise that Sixth Amendment right to counsel, then he has that right, and the police must go through his counsel. Two main differences. One is that only applies to the offense with which he's been charged, right? That only applies to the offense. It's what we call charge specific. So is the Fifth Amendment right to counsel always charge specific? No, it might be all offenses if he invokes his right to counsel and remains in continuous custody, right? It might cover all offenses. Fifth Amendment. Sixth Amendment right to counsel, never. Sixth Amendment right to counsel, always charge specific. Okay? If it's a different charge, the same officers can question him, different officers can question him. Now, I believe that we have some slides here to talk about those distinctions. The one in the middle, page 12, clearly states either of these rights can be waived. You don't have to have a lawyer to help you decide whether to waive them, either one of them. If you waive your Miranda rights, that's effective as both a waiver of your Fifth and or your Sixth Amendment right. And then the Montejo case, and I understand Judge Jarvis was here with Mr. Willett at one point talking about Montejo, is that right? I knew that. He and I prosecuted some cases where that was a major factor, the Montejo decision which overruled Michigan versus Jackson. And Michigan versus Jackson was a case that just said, as soon as he has a lawyer, the police can't go right to him anymore. Now understand a couple of things, okay? One is the Constitution affects, what anybody acting on behalf of the government. Okay, it affects, the police can't do it, the prosecutors can't do it. No one acting as our agent can do it if the Constitution says we can't do it. But there are other rules that deal with professional responsibility, ethics, with attorneys. Now, once he has a lawyer, and this is true in a civil or a criminal case, once a litigant has a lawyer, other lawyers in the case, whether it's a prosecutor or an attorney representing a co-defendant, you must go through the lawyer, but not the police. So if any of you have heard, that you can't do that because of ethical opinion, that's not the police. The Constitution is what restrains the police. Okay? Prosecutors are also constrained by rules of professional responsibility. So once I know this defendant has an attorney, I ain't going to talk to him. But the police can. And at one point, there was a big discussion among the Virginia bar as to whether prosecutors can advise the police that, yes, they can legally go talk to somebody who's already represented without that person's lawyer with him. And there's no question but that we can do that because they are allowed to do that. Now, badgering, still can't do it. But what Montejo says is it overruled Michigan versus Jackson, which barred police-initiated interrogation once the defendant had invoked the right to counsel at an arraignment or at a similar proceeding. Police may now approach the defendant even after such invocation, and if the defendant waives Miranda, he may obtain a statement from him. So if he's represented by counsel and he waives his Miranda rights, that's saying I don't want a lawyer here. And the U.S. Supreme Court said in Montejo that was good. And look at their rationale. The ready ability to obtain uncoerced confession is not an evil, but an unmitigated good. And the marginal benefits of the Jackson rule are far outweighed by its substantial cost to the truth-seeking process, and it is therefore overruled. Now, we already knew that if a defendant, a person who's charged, contacts a police officer and says, I want to talk to you, I don't want my attorney here, I want to talk to you, what should the police do? Can they go talk to him? Sure, absolutely. That's definitely what the police officer should do. And in the Montejo case, and hopefully you read it, You can see, you know, what happened there. Well, the defendant committed a murder, was arrested, confessed to the police, cooperated with the police fully, was placed in jail, got appointed an attorney. The attorney comes to see him. A day or two later, the police come back to him and say, hey, how about going and helping us, show us where you threw the gun, where you threw the murder weapon. He said, okay, let's go. No attorney, right? But out of an abundance of caution, because he was locked up, they said, you know, here's your Miranda rights. You remember you have these rights. You want to waive and come with us? Sure. Boom. U.S. Supreme Court said that Miranda waiver acted as a waiver of Sixth Amendment rights also. And along the way, what'd they do? Why don't you write an apology to the widow of your victim? He says, it's a good idea, why don't I do that? And of course, that's what was used against him, that writing. And I think I told you, these cases that deal with confrontation, you don't have to concern yourself with. We're not going to be asking any questions about that. Are there any questions about any of that Miranda information that we just went over? Let's talk about some examples. Let's talk about some examples. True or false? Once a defendant in continuous custody has invoked his Fifth Amendment right to counsel, he may not be questioned by anyone from law enforcement, even officers who are investigating an unrelated case who are unaware he has invoked his rights. How many think that's true? How many think that's false? How many think about it at all? Try it again. Once a defendant in continuous custody has invoked his Fifth Amendment right to counsel, he may not be questioned by anyone from law enforcement, even officers who are investigating an unrelated case, unaware that he's invoked his rights. How many think that's true? How many think that's exactly what we just said? I do. I think that's exactly what we just said. Once he's invoked his right to counsel, he cannot be questioned by those officers or any other officers about this offense or any other offense, so long as he is held in continuous custody. I believe that's exactly what I just said, right? You got questions about it? Now's the time to raise them. All stops and seizures of a person constitute custody for Miranda purposes. True? False? All of y'all are going to have to answer these. All stops and seizures of a person constitute custody for Miranda purposes. Is that a true statement? When a police officer pulls you over for running a stop sign, is he going to give you Miranda warnings? No. Is that custody? No. That's a false statement. When a defendant in custody invokes his right to remain silent, the police may not later approach him for questioning. True? False? Now we're talking. False. Miranda warnings are not required for custodial interrogations by private citizens. Well, first thing you're going to say is, wait a minute, private citizens don't conduct custodial interrogations, do they? Well, you know, maybe some private citizens will walk in and the guy's locked up. Maybe he's got a visitor. And he starts asking questions. Why'd you do it? Without Miranda warnings.